Hi, welcome. I am Jeff Greenbaum. I am the head of public policy of the International Advertising Association, and I'm also in the various hats that I wear. Managing partner of Frankfurt, Kerner, Klein and Sells, where I'm an advertising lawyer, and also I'm going to be joined in this webinar today with a bunch of my friends from the Americas, who I'm sure will pop up on the screen right now, who are all members of the Global Advertising Lawyers Alliance, of which I'm also the chairman. And so what you can see, I don't know if everyone's squares are in the same spot, but you can see Damaso Pardo there from Argentina, Adrian Martinez from Mexico, and Kelly Harris from Canada. We are all lawyers who practice advertising law, and we are here together partnering with IAA to talk to you about developments about environmental advertising regulation in the Americas. Why are we talking about this? We're talking about this for a couple of reasons. Number one, the IAA is really focused on sustainability issues. We have a lot of different initiatives going on throughout the organization to highlight the importance of sustainability, both as a social good, as a driver of brand value, and as part of this, we're really looking at how can we provide information to marketers around the world about how best to advertise and not cross the line in terms of legal compliance when making environmental claims. We're also at a time right now where companies realize how important climate change is and how important climate change is to consumers. And because of that, companies are making a lot of environmental marketing claims. But at the same time, what we're also seeing around the world is a real evolution in terms of the guidance that's out there. Regulators, self-regulators are issuing new guidance, are considering new guidance, and we're also seeing increases in litigation around the world and just general increased attention to these issues. So it's the perfect time, both for IA and for all of us, to be taking some time to think about these issues. This webinar is part of an annual webinar series that the IAA does every year, focusing on important emerging advertising regulation issues around the world. This year, all of our webinars are focused on sustainability. We're doing, I think, 3 this year. We've done 1 already, which was focused on environmental marketing claims in Europe. If you're interested in seeing that, you can go to the IA's website and you can watch it there. This one is focused on environmental advertising in the Americas. And then this fall, we're doing an environmental, our final webinar, which is going to cover, Middle East, Africa, Asia, some other parts of the world that we haven't covered so far. So with that very, very brief introduction, I'm going to make sure I know how to change the slides. And yep, there we are. There's our picture, so you can see us and our picture pretty much the same. Yeah, we do. We look the same. And okay, so the first thing we want to do before we sort of dive into the specifics is give you a brief overview of the ways in which environmental marketing claims are regulated around the world. So in the United States, all advertising is governed by a patchwork of federal and state law. So you can have identical laws in federal and state law, you can have conflicting federal and state laws, you can have inconsistent federal and state laws. But when you're thinking about compliance with advertising, you have to think about both what's going on federal and state level. There are, of course, in the United States, general prohibitions on false and misleading advertising, and certainly those would apply to environmental marketing. But pretty much the starting point in the United States when people are talking about environmental marketing is the FTC's, what we call them the green guides, so the guides for the use of environmental marketing claims. And basically what these guides are, and these guides have been around for decades now, what these guides are, they're not regulations, they're not rules, they're not actually independently enforceable. They're simply the Federal Trade Commission's sort of guidance or view about what it believes are the types of practices that would violate Section 5 of the FTC Act, which prohibits unfair, deceptive acts or practices. The green guides have general guidance about making environmental claims. They've got specific guidance about specific types of claims, and they provide lots of examples about how to make those claims. So if you're going to advertise biodegradable, you look in the green guides. They tell you what they believe biodegradable means, and you try to comply with that. What's very, very interesting, though, and what's happened over the last several years is that many states have also started to enact specific advertising laws related to environmental marketing. And let me just tell you 2 quick things about that. Number one, some states have actually adopted the green guide as law in those states. What does that mean? That means that even though the green guides themselves are technically not law under federal law, they are under state law. That's number one. Second, the states have enacted and are continuing to enact specific laws that relate to specific environmental marketing practices. So, for example, recyclable claims or compostable claims or things like that. So, if you when making those claims, it is important to make sure that you do not rely just on what's in the green guides, but you actually have to look specifically to state law to see what's going on there. All eyes right now are on California. California issued, I don't know, a year ago, maybe not quite that long ago, a potentially much more restrictive law or specific law on making of recyclable claims. We're all waiting for the regs to be issued under that statute. And once that happens, we'll know a lot more about kind of what the scope of that law is going to be. And finally, in the United States, we have a very, very well-respected self-regulatory system, the National Advertising Division, which also issues its own guidance, not codes, but decisions on environmental marketing claims, which impact the way we approach these claims as well. So that's the landscape in the US. Now we'll go to Kelly.
Thanks so much, Jeff. So in Canada, we have a very similar structural approach as there is in the US, where there is both federal legislation, provincial legislation, self-regulatory guidance, and regulatory interpretation of their laws, both generally for advertising and also specific to green environmental claims. So the main prohibition, prohibiting a false or misleading representation is the Federal Competition Act's Deceptive Marketing Practices section. And they have a general rule that, prohibits making any sort of false or misleading claim. There are also laws in that statute that require claims to be properly supported. The Bureau had a very detailed environmental claims and greenwashing guidance, very similar to the green guides in the US, that it published in 2008. But as you can imagine, a lot of the standards and science, frankly, that underpinned that guidance evolved, and that was archived in, I think, 2022. So now there is a very high level piece of guidance from the Bureau, which is very principles based. So not quite as detailed as the green guides in the former 2008 guidance. Under provincial consumer protection legislation, there are very similar prohibitions against making deceptive claims. A lot of that is kind of tied around agreements with consumers. So if you're making a representation in the course of sale or as part of an agreement, that's when those provisions will apply. And what's kind of different about them is that they give much stronger rescission rights to consumers, which means if you make a misleading green claim while you're selling a product, consumers would get the rights under those statutes to say, I no longer have to be in that agreement for purchase, which can be a big deal on a class basis. We also have a very strong self-regulatory organization, Ad Standards, and it administers the Canadian Code of Advertising Standards. And under that code, it does have an interpretation guideline specific to environmental claims. In that interpretation guidelines, it references the Competition Bureau's very high-level guidance. And it also references the application potentially of the ICC's framework for responsible environmental marketing communications. So when Ad Standards receives a complaint from the public or NGOs or competitors regarding a deceptive marketing claim, they may reference those external counsel or the adjudication panel may reference those external guidelines in making their determination of what the general impression of the claim is, for example. And there are some kind of specific industry laws that you need to be aware of. A big one that's come up in the ESG space is securities regulators coming out and issuing guidance on claims that companies are making in public-facing documents like press releases, talking about, for example, the funds that they are going to be funding, future-looking claims. These are all things that securities regulators are now taking an interest in, and the Canadian securities regulators published guidance on this. There are also, very specific kind of statutes, the standards for compostability, like for the actual compost itself. So depending on the kind of claim you want to make, there could be very specific industry overlay over top of those general laws.
Okay. Thanks,
and
Kelly.
I come over to Mexico next.
All right. Yep. Here we go. Adrian.
Hi. Well, first of all, thank you for having us here. It's very interesting to discuss these topics and to see how they are regulated in other countries. And yes, I think this is a very important issue in Mexico right now, and it's trying to be addressed because greenwashing is a real problem in our country. For example, earlier this year, there was a journalistic report that looked into 24 of the biggest companies in Mexico that claim to be environmentally friendly or have sustainable practices. And it turns out that out of those 24 companies, only 23 comply with the current rules that say that they can actually be a real environmentally friendly company. So it's part of the problem that this article indicates is that the lack of a specific policy or lack of enforceable rules that could force these companies to try to do these practices is why they are able to get away with it, to say that they are green when they are not actually doing those activities. So there is no specific legislation related to advertising for green advertising or environmental practices, but like in Canada and in Mexico and in the US, I'm sorry, it also falls under the general consumer protection clause that says that companies cannot make claims that are false or misrepresent claims, and that all of the claims that they do must be substantiated and backed up by real evidence. So, for example, the law indicates that if a company in their advertising or their information they give about their product claims that the product has some characteristics, they must have the elements, scientific, objective, and reliable elements to be able to back up the and actually a failure to comply with those rules, if you claim falsely that you have some environmentally friendly characteristics, could lead to considerable fines. The fines can go from $10,000 to roughly $2,800,000, depending on the case. And depending on the severity of the claim, it can be also an additional fine of up to 10% of the revenue of the infringing product. However, I think that the biggest problem in Mexico is not that the law isn't that great, is that the authorities sometimes do not have the economic or human resources to do this. I believe that, for example, the Federal Consumer Agency that it's currently in Mexico, most of their activities are intended to protect consumers in actual transactions. For example, when a provider or a supplier is not complying with the terms that they were offered, or the prices are not being respected. And so they do have an arm that it's intended to enforce all of these rules regarding false claims, but it's not the main focus of the agency. So that's kind of a problem when these kind of activities come up, because like I said, if there is no real enforcement, companies can sometimes get away with doing illegal stuff and there is no more punishment. So I think that's a general advertising, the most important advertising rule, but there are other rules that are a little less related to advertising, but that are still relevant. Like in the US and Canada, we have some self-regulation. There are some non-governmental bodies that institute policies and institute all of these rules that are not enforceable but are optional for companies. And so they can use them to claim that they have been endorsed, for example, by certain organizations that can certify the activities of these companies. For example, falsely claiming to be endorsed by an organization is also an infringement under the consumer law. And besides that, I think that the other important things is that there are different other kind of rules which are not exactly laws. For example, Mexican standards or official standards, which are very industry specific. So if you are in a specific industry regarding for example, treatment of garbage or recycling or stuff like that, you have to comply with some rules to be able to operate lawfully. And likewise, if you cannot operate lawfully, you cannot advertise lawfully. So I think that those are the more important rules. And well, finally, this is not a specific enforceable law, but there's an interesting effort by the government. This last part that you see in the slide, the label guidelines for sustainable consumption, this was a project created by the Ministry of Environment and Natural Resources, not by the consumer agency. And the purpose of these guidelines was to provide some clarity for the consumers in the market. The government looked at the market and said, okay, there are around 30 to 40 eco label seals that are going around in the market, and that make big confusing to the public because they see some kind of eco label that says that a product is sustainable or the product is certified by this organization or that organization, but it's not always clear which are the actual characteristics of those products. So these guidelines are a means to inform the public of which are the characteristics of each eco label so they can uh, make a more informed decision about the product that they are consuming. I think that that's the general overview of Mexico so far.
That's great. All right. And last up, Damaso.
Okay. Now, first, I think it's important to mention that Argentina doesn't have a code on advertising or a general law on advertising, but rather you can find rules and regulations in different laws, codes, and resolutions. So, in that regard, of course, one of the main laws are the loyal competition law, which provide, of course, for adequate, complete, and accurate information that should be provided to consumer. One article of the Code and Civil Commercial of Argentina, which mentioned that false statement that confuse the consumer, of course, are not allowed. Article 10 of the Paris Convention is still completely applicable. And some articles of the Consumer Protection Law also. Well, having said that, the only place where you can find this topic specifically addressed is in the guidelines of CONARP. CONARP is the self-regulatory body of Argentina. Although it's not enforceable or mandatory, it's a very relevant players. I mean, Argentina doesn't have too much litigation on these issues, but are rather all the conflicts are rather solved at CONARP. Why? Well, because 90% of the main players, companies, local and multinational companies, are members of CONARP. So it's a very well-respected body, and it works very well. We have a long tradition of using CONARP as a way to solve disputes. Well, what we can find in the guidelines of CONARP, of course, are some rules which mainly were taken from WFA, ICC, and ACNS. So basically, the first one is, I mean, you are not to mislead consumers when you advertise. The advertising and any statement related to environmental issues might be capable of substantiation. The substantiation has to be objective, serious, and done by an independent scientific institution with a strong knowledge of the business or the area of the advertising. Of course, communication should tell all information and be made in a way that is understood by any consumer, but the average consumer. And any features of the product related to to advertising on environmental issues will be related to the full life cycle of the products. And then, of course, you can make a clear statement on what is the impact on the environmental when you advertise a product. This is mainly what's going on in Argentina in terms of regulation.
All right. So with that background, let's jump into a bunch of specific topics and sort of go through those. So not going to spend a lot of time on the United States to talk about substantiation. The rules are clear. If you make an advertising claim, whether an express or implied claim, you need to have a reasonable basis for that claim. When you're talking about statements like health and safety and other kinds of claims that would require a more substantial basis, then the FTC expects you to have competent and reliable scientific evidence to back up the claim, and the FTC seems to get stricter and stricter about what its substantiation requirements are. I would say when you're thinking about green claims, often that is going to be the kind of evidence that you need. The two things that I really want to point out here are kind of number one, that is not the endpoint of the analysis. What we're seeing in state law now is some states defining the specific substantiation that you need. In other words, if you're going to make a compostable claim, you must have this home certification or something like that. So it's important for you to understand, if you're making a specific claim, what the state law impact of that is going to be. The second thing is right now in the US, in most situations, you're not required to either provide the basis for your substantiation in the advertising. It's enough just to have that substantiation, and you're not required to make it available to consumers. We're starting to see some indication that we're going to see some state laws that are going to have requirements like that. So something for advertisers to keep in mind, that there may be situations where you're going to need to explain what the basis is for the claim, to provide a certification showing that you've got substantiation for it, and even have a process in place to provide consumers with your backup. Kelly.
So in Canada, very similar. We have, the first kind of step you take when you have a claim is to determine what the general impression of the claim is. And so we consider the advertising as a whole through the lens of a credulous and technically inexperienced consumer who's only looking at the advertisement one time. So it's kind of the idiot in a rush test. So this particularly becomes an issue when it comes to a lot of these environmental claims are a little bit more complicated than a number one sales claim. So you have to be really careful about how you're positioning the claim and making sure that you're not getting into too much detail that an unsophisticated consumer is gonna understand. So when it comes to substantiation, it's the adequate and proper substantiation. So it's going to depend on what the claim is, what support you're going to need, but it has to be on hand before the claim is made. Even if it's true, you can't do your homework after you've published your claim. It needs to be controlled, eliminate subjectivity. It doesn't need to be certainty, but it can't just be mere chance. You need to have material results, and critically, the testing needs to support the claim that you're making, right? And that's where I see a lot of things start to diverge, where you have good support for something, but the claim gets workshopped so much that it no longer really means that the general impression is not really aligned with the support you actually have on file. And then on the self-regulatory side, it's very similar. It's competent and reliable. If you're relying on survey evidence and that sort of stuff, it's reasonably competent and reliable. So it's very similar to the US in terms of what you need to support your claim.
Okay. Adrian?
Yes, well, I think this is very similar in Mexico as well. Like I said, the law indicates that in order to make a claim, especially a claim about these kind of things, you have to have a scientific, objective, and reliable evidence, usually documentation, that can support the truthfulness of what you're claiming. So there are no specific rules on how you should create these documents, but they should pass an objective test if they are challenged. Like in the US, you don't have to provide all of this information to the consumer in the day-to-day basis, but the authority may require it at any time. For example, if they receive a claim that you are conducting a misleading advertising. So those documents must be ready to be shared with the authority, submitted with the authority in a response, to be able to prove that you are complying with the law. This is more important when your industry is related to specific Mexican standards, because in those cases, like I said, they are usually included as requirements to lawfully operate some kind of businesses or some kind of industries. So in those cases, it's not only a thing that may come up when the authority is trying to confirm that you are complying with the law, but it's also something that your company or your business will require to be able to actually function. And I think that in large part, the way that this advertising is done in Mexico is through eco-labels. I will talk about that a little bit more later, but the presence of eco-labels has led to the government delegating this kind of review and confirmation to other bodies. Because, like I said, the government will make sure that if you're using a label or claim to be endorsed by an organization, you actually have a way to support it, but they will not actually review if you have the requisites to be endorsed by that kind of certification. So, for example, in these label guidelines that I mentioned, which are published by the Ministry of Environment and Natural Resources, they even cite the American EPA, saying that it's complicated to claim when a product is green. You can maybe say that a product is greener than another, but there is no specific criteria, or is not always a specific criteria of which requirements should be met to claim that a product is green or greener than another one.
Great. Thanks, Adrian. Okay, Damaso.
Well, in the case of Argentina, again, there are no specific statutory rules. And what we can find is guidelines in the self-regulatory body, CONARP, which, as I mentioned, is a very relevant player in these disputes. The substantiation must be robust, objective, and ascertainable. And again, it should be made by an independent scientific entity with knowledge of the advertised products.
Great, thanks. Okay, next topic. Are general environmental benefit claims deceptive? In other words, if you claim that a product is green or eco-friendly or earth-friendly, is that just puffery, or is that a claim that the regulators would be concerned about? In the United States, the Federal Trade Commission has said very clearly in the Green Guides that it believes that general environmental benefit claims, things like green and environmentally friendly, are deceptive, and they believe that they're deceptive because they're likely to be interpreted in a variety of different ways, communicating a variety of different claims that are unlikely that advertisers can substantiate. What's the FTC's guidance here? The FTC's guidance is, instead of making a general claim, make a specific claim. Don't say it's green, say it's made of 100% recycled material. If you absolutely have to make a general environmental benefit claim, then what the FTC wants you to do is to qualify that claim and explain exactly what you mean. This claim is green, this product is green because it's made of 100% recycled material. But you do have to be clear, you do have to be careful, however, that if you're going to make a general environmental benefit claim, even one that's qualified, you have to be careful that there aren't other implied claims that are communicated that suggest that the product has overall net benefits to the environment or something like that. We have seen lots of litigation out there, private litigation, in self-regulation, looking at these kinds of environmental claims. And advertisers are pretty unsuccessful at getting these cases dismissed. Lots of people are out there using sustainable, and then when they get sued because someone claims that your product does in fact have adverse impact on the environment, courts pretty much say, yeah, sustainable is a claim. You are going to actually have to back that up. Same thing with things like environmentally responsible. So something to be very, very careful about in this area, particularly because we're seeing so much attention on it. Kelly?
Yeah, I would say probably the same analysis in Canada. It's very likely that a general environmental benefits claim would be considered to be deceptive in Canada. I said earlier that the Competition Bureau's current, regulatory interpretation is very high level, but this is one of the issues that they are quite clear on in their guidance. And I've actually reproduced it on the slide here. And their guidance really is, be specific, be very clear about what the specific environmental benefit of your product is, and avoid vague claims, specifically eco-friendly or safe for the environment. And really what it comes down to is what does that mean, right? If you have a very vague claim, the general impression is, possibly from a idiot in a rush, is going to be that your product has a much larger environmental benefit than whatever it is that you actually have to support that claim.
Great. Okay. Adrian.
Yes, in Mexico, it's the same idea. I always tell the clients that the broader your claim or the less specific your claim, the harder it will be to substantiate it. So if you are making something general like eco-friendly or green, you will probably maybe challenge in case the authority initiates an investigation. Actually, for example, this is not exactly related to environmental, but to put an example of how this works, there is a popular beverage in Mexico, whose slogan in Mexico is "Qué buenos son," which translates that they are very good. It's a beverage and the claims are very good. And they're currently under investigation because the Federal Consumer Agency are saying, well, what are they good for? Like, you have to be more specific, or if not, you cannot be able to use that general statement saying that your product is good. So that, in this context, will be a very good precedent on how, if you make a broader vague statement of how the quality of your product, it may be hard to substantiate it, and it may be complicated to avoid some kind of sanction because of this.
Great, thanks. Tomaso.
Okay. Now, in our case, I mean, maybe in most of the cases, of course, a general abstract statement like zero emission, eco-friendly, green are deceptive, or most likely be deceptive. But in any case, any general environmental benefit claims should make reference to the current features of the product and their impact in the environment. I mean, they have to provide some relevant information to the consumers. And of course, should be also substantiated through technical and scientific methods. The claims must be precise and clear for average consumers. These are the main rules on this topic.
Great. Thanks, Tomaso. Okay, next topic I want to talk about is a really interesting emerging issue, which is do aspirational claims require substantiation? You know, one of the things we're seeing a lot of right now is companies making broad commitments about how they're going to lessen their impact on the environment. We're going to be carbon neutral by 2030. Our materials are going to be made of 100% recycled material by 2025. You know, what kind of substantiation do you need for those claims? You know, in the United States, we've gotten some guidance on this. We've seen our self-regulatory system look at this. We've seen courts look at this. You know, well, my view about this is that aspirational claims are likely going to be claims that require substantiation, particularly when they provide some sort of specific information about what you're saying. You know, if you're saying your product is going to be made of 100% recycled material by a certain date, you better be able to back that claim up. And how do you back that up? Well, what the NAD has said is that you really need to do two things. You need to say, number one, that you have a reasonable plan in place to achieve those goals. In other words, you can't just set the goal. You really actually have to have a thoughtful plan in place that shows how you're going to get there. And two, the NAD is really looking for you to take some to show that you've actually taken some steps to start to get there. I'm not sure that that's necessarily what the law would require. I think it's more a question of really, you know, if you're going to get there, you know, do you have the kind of business plan in place that would allow you to get there? Very, very interesting, though, in one recent litigation against Coke, where Coke had made a variety of aspirational claims, some very, very general and some very, very specific. The court held not claims, don't require substantiation for it, not worried about those. And the reason was the court felt like, look, promises about what you're going to do a long time in the future just aren't the kind of claims that consumers would expect you to back up. Whether the holding in that case gets followed by other courts, who knows? But it does show that this is one of those areas right now where we're in flux, and there's not necessarily kind of a uniform approach to how to deal with it. Kelly?
Yeah, I think it's a really interesting topic, and one that you know, we're seeing in Canada actually being picked up by nonprofit and interest-based groups. And so just to give some context on this, there is a provision under our Federal Competition Act which allows, you know, I think it's 6 people or 11 people, and if a number of people come together and submit to the Competition Bureau a request to launch an inquiry, they are obligated to do so. And what we've seen is these NGOs use this provision to kind of highlight claims that they think are misleading, and particularly, you know, these kinds of more thorny issues, like a future-looking claim or sustainable claims. In this case, the one that's on the slide is from October. A bunch of NGOs use this provision to highlight one of the big banks in Canada's future-looking sustainability claims. And so they made a bunch of, you know, very common, I would say, ESG commitments. And the complaint from these nonprofits is that, this bank is also financing fossil fuel projects. And how can they make these claims about building a sustainable future while also financing industries that are a big, contributor to, carbonization in the environment? So I think you got to be really careful about aspirational claims. And I think that the stakes are really sort of shifting, particularly with, the environment being such a huge issue. In Toronto today, we have more, air quality issues from the wildfires in Quebec. And it's something that, is really a burning issue. And I think that...
no pun intended.
Yeah, truly.
Thanks for that, by the way.
Yeah, you're welcome, everybody else. And thank you to, France and all of the other firefighters who are coming to save our forests. So I think it's a really tough area. And I think it's kind of expanding into, not just your typical advertising claim, right? We're looking at, press releases and, kind of corporate comms that were never really part of, a legal review from this perspective. We're really shifting the goalposts here.
Okay. Adrian.
Well, there is no specific address to the aspirational claims in the law, but like I said before, it all falls under the general misleading or false claims advertising. So in general, yes, they should be substantiated, and maybe complicated to substantiate it. So I think that the most important part about this kind of aspirational claims is how to formulate it. How do you share them with your clients or share them with the general public? Because like I said, the broader it is, or the more general you go into it, it's going to be harder to actually substantiate it. But if you are trying to say something like, we're striving to be, for example, carbon-free by 2030, as long as you can provide that you're doing reasonable efforts to do that, or that you are putting in place all of these programs or all of these efforts to achieve that goal, you should be able to substantiate that claim. So it's very important to, that's general. Yeah.
Thanks, Adrian. All right,
Well, no, all of the rules we mentioned from the very beginning, of course, apply to this kind of advertising, aspirational advertising, aspirational claim. But there are not a specific rule addressing this subject. Again, we find some rules in the guidelines of the self-regulatory body in Argentina, and any aspirational claim must be able to show evidence to demonstrate on a reasonable manner the capacity to fulfill the proposed aspiration. I mean, they have to have any reasonable evidence to prove that they can do that in the term provided in the act. And of course, they should be substantiated through technical and scientific methods.
Great, thanks. All right, next hot topic. What are the rules on making claims like carbon neutral, net zero, and other claims related to the way in which your carbon emissions have been reduced or offset? One of the difficulties about thinking about this issue in the U.S. is that the first place we look, as I mentioned, is the Green Guides, and the Green Guides are more than a decade old at this point. And when the Green Guides were issued, whatever it was, 11, 12 years ago, they were really, when they talked about sort of carbon neutral issues, they were really thinking very, very specifically about kind of the advertising of carbon offsets, meaning take this flight and you can offset your emissions by buying these credits from this program. And the FTC was very, very focused on this notion of, are you properly calculating what the emissions are? And do you have proper accounting methods to make sure that if you're buying an offset, it doesn't get sold twice, and that it's actually matching up with what you're saying has been offset? That's kind of the sum total of the guidance that we have at this point. We don't really, and they were concerned as well about making sure that if you're going to claim that you've offset some carbon emissions, that offset happens within a reasonable period of time. What the Green Guides don't address, and what I imagine that they will address at some point in the future, is this whole idea of making a claim like carbon neutral net zero. And one of the difficulties with this claim, and I think one of the things we've seen as we look at the ways in which self-regulators and others around the world have been thinking about this claim, is there's a concern out there that consumers are not going to understand that net zero and carbon neutral is about carbon offsets. And so the thing that we're thinking about a lot right now, in the absence of guidance on this issue, is do you really treat net zero or carbon neutral not as a claim that consumers will understand it to mean simply we've offset our carbon emissions, but do you actually have to treat it more like an general environmental benefit claim and really explain to consumers what you mean by it? Meaning, do you need to say, we're net zero, that we want to be net zero by 2030, which means we're either going to reduce our emissions or we're going to buy offsets to offset the emissions that we generate. Kelly? Kelly, you're on mute.
Sorry, I would agree with that in terms of, what is the claim and what is the general impression of it. And I think that, we have to be really careful about making sure that we're explaining environmental claims, including a net zero claim and what that means. And I also want to highlight that there's actually a lot of work to determine how much carbon is used in your product, right? Like it's not to do a life cycle analysis is not an easy task, right? Like the carbon used in the product life cycle is, pre-production, through transportation. Like it's sort of a big undertaking to make sure that you know how much you need to even offset. And then, when you're buying these, carbon offset credits, a lot of due diligence is required on these companies as well. And sometimes they come to me and, the business team has not really done any due diligence on whatever vendor they're purchasing from. And, that's a really important part of determining whether you can support a claim, particularly if you are talking about future offsets, right? And another big issue and question that comes up is, how is it actually going to be offset, right? So is there going to be a delay in implementation? Sometimes it's, through projects in the future that are going to, prevent a forest from being cut down. And that's a project that's being used as part of a carbon offset calculation. Like, is that really, net zero if your carbon credit is on the basis of not cutting down more trees in the future? And these are kinds of the details that you need to kind of really look at, right? It's easy to just kind of, there's a third party, they're selling these credits, but what does that actually mean? So it requires quite a lot of work to dig into each of these aspects. So don't underestimate the kind of scope of project if you're, using a life cycle analysis and then buying carbon credits, in addition to everything Jeff said about, what does it even mean to be net zero? And do people understand that?
No, it's such a good point. I mean, I worry that, when we thought about this whole idea of carbon offsets, regulators weren't fully able to predict, the way what people would define as a carbon offsetting project. I mean, the FTC, I think in a way, the FTC thought about it as in you're going to plant a new tree, right? And that tree is going to offset your flight, something very, very specific. But clearly, there's a lot of other things going on right now that are very, very different than that. And I think only time will tell how regulators interpret it. Adrian?
Yes, I would discourage clients from saying that they're carbon neutral or net zero if they don't have the proper means to back it up. Mexico created a new law in 2012 in the context of joining the Paris Agreement with the purpose of providing policy rules of the government to how to manage all of these topics. So this law, while it's complicated to enforce it in some places, has been very active. It was actually just amended last year, and it has been a constant effort of the government to try to address these topics with mixed results, but they're still in the law. So one way to try to prove or to claim this without incurring too many risks is to try to do these voluntary certification programs in which, like I said, an independent body sees if you met a bunch of requirements and see that they can give you the certification. So it's easier to use one of these certifications because you are supported by these organizations than to claim that you are carbon neutral or net zero in the vacuum or without any further support. For example, there was a very important case last year in the World Cup in Qatar, where the Mexican football team obtained the certification and they claimed to be one of the carbon neutral teams that were going. They say that all of their trips and all of their efforts and the uniforms they use for this World Cup were created with this certification so they could ensure that they are carbon neutral. So they are not claiming to be carbon neutral in a vacuum, but they are claiming to have this certification, and this makes a much safer claim. Other than that, and with this piece of legislation in force in Mexico, I would not recommend the clients to do these claims very freely.
Damaso?
Well, again, there are no rules on carbon neutral claims in Argentina, and there is no obligation to reduce or mitigate greenhouse gas emissions. So also, there are no rules on mandatory carbon neutrality or offsetting claims. This is something very not regulated in our country. But of course, we have to rely again in the guidelines of CONAR, the self-regulatory body, and any of the rules, all of the rules we have been mentioning in the other issues in this conference apply to this. Certain areas are specifically looked like capital markets or any company that make an affidavit or source statement mentioning any of these characteristics. All the oil companies, the oil sector also is very strict there. And in Argentina, what we have is an obligation for the government and for certain companies to provide environmental information to the citizens and consumers. And last, Argentina recently approved a regional agreement on access information and justice in environmental matters. It's the Escazú agreement, which has practically all Latin American and Caribbean members of this agreement.
Okay. All right. Next topic. When can you claim that a product is recyclable? This is a very hot topic in the US right now. I mean, the green guides themselves have pretty clear guidance on what that means. You know, if you're going to claim a product is recyclable, basically means that it can be recycled as part of an established curbside recycling program. And if you're going to make an unqualified recyclable claim, those curbside programs need to be available to a substantial majority of, you know, people or communities where the product is sold, and substantial majority means about 60%. You can also make a qualified claim as well. So it's recyclable by bringing it back to the store. It's recyclable in a specific way. Those kinds of claims are permitted as well. In the U.S., you're also permitted to exclude incidental components like the bottle cap or something like that. The emerging the two issues that are sort of floating around right now that I think that the FTC is wrestling with, and the FTC just held a workshop on recyclable claims are, you know, number one, are consumers getting it right? Are consumers communicating well which products are recyclable and how? And I think one of the big concerns that came out of the workshop was that although this guidance is clear, marketers aren't quite getting it right when communicating that information. And then the second question is, which is a bigger, scarier question is, you know, what is an advertiser's responsibility for ensuring that the recycling facilities themselves that collect and or ultimately accept the material actually recycle them? You know, one of the concerns is that not all material that gets submitted for recycling ultimately gets recycled just because of the limited capacity of recycling facilities, because of contamination, because of other issues. And the FTC is really asking the question, you know, if you make a recyclable claim, you know, will consumers understand it to mean that it will in fact actually be turned into something else? Clearly, if you make a claim that it is actually being turned into something else, you better have substantiation for it. And there's a recent NAD case on that. But so far, courts that have looked at this issue have basically said, no, you know, a recyclable claim doesn't mean that it was in fact turned into something else, just that it was capable of being recycled in accordance with these systems that are in place. Kelly?
Yeah, it's also a really hot topic in Canada. You know, we also have a very mishmash system of facilities for recycling. So it's down, even within one municipality, you know, you will have different facilities that accept things differently. There's not really a set standard of, if something is able to be recycled, whether or not it actually is recycled by the facility. And, sometimes there's issues of, things getting thrown in the garbage because they've been contaminated. So it's, I think a big factor to recyclable or compostable claims is just the on the ground facilities are just run by a million different private and public operators, and there's no consistency or harmonization or even a way to easily understand what they're currently accepting on a given day, unless you call them. Like, it's that level of kind of decentralization. And this came up in a case last year with coffee cup pods, which were in fact recyclable, but just not everywhere. And you can see this, sorry, the examples are so small. They, in the original advertising, it said currently recyclable in select locations, but that was in the disclaimer at the very, very bottom there in the black and white version. And so Keurig entered into a consent agreement with the Bureau, and as part of that agreed to change the claims to make it more clear. I think it was only in Quebec and BC where facilities existed, which is not, we don't have that 60% threshold in Canada and any sort of regulatory guidance, but 2 of the provinces of 10 is not going to probably cut it. So you can see in what they've revised in the green one, they've moved that claim up to the top, right? It says, that's right, Keurig Cape Cup pods are made of plastic, blah, 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 and are recyclable in select locations in Canada. However, they may not be recyclable in your area, asterisk. And then it goes down to the disclaimer. So this is a tiny change, right? But again, shows how important it is to be clear to that, unsophisticated consumer, and don't rely on disclaimers to give material information like this. So really hot topic, and, something to really watch out for in Canada.
Adrian?
Yes. Well, there is no specific regulation in Mexico so far regarding recyclability or to claims of recyclability, but there have been efforts to do it. For example, there was a law that was discussed by the Senate in 2021 about general circular economy law, and this law included some rules about which products could be recycled, how the recycling products should be carried out, which requirements should be met to be able to function like this. And so the Senate approved this on November 2021, and then the bill was passed to the Chamber of Representatives to continue this approval, and they have done nothing with the law since then. So it's approved by only one of the legislative chambers, and so this is not a law that is currently enforced, and these rules are not currently applicable in Mexico, and in a federal level at least. Earlier this year, the government of Mexico City did pass a local law addressing many of these topics, and it also includes a new certification about companies that comply with this law and that may be able to say that they are recycling in accordance with these provisions of the local law. So, like in the other things, as there are no general rules about which characteristics a product should have to be considered recyclable, the idea should be to try to comply with international standards, comply with the standards of an organization, or in case if you're in Mexico City, to comply with this new law, because like that you can claim this in a more broader manner. Since Mexico City approved this, there has been a lot of talk about it in other states, and maybe this will be a cause for this federal law that was discussed in 2021 to be brought back to the table once again. But so far there are no plans in the federal legislature to approve of this law, so we will have to wait and see.
Okay. Again, in Argentina, we don't have specific rules on this matter. The most closed rule would be from the commercial loyalty decree that provides that the product has to have adequate, complete, and accurate information provided to the consumers. And what is interesting in this law is that you don't have to prove the existence of current damages, but only a potential damage to file the action. So it's very, very strong against the false advertising. Of course, claim must be substantiated, and it's important to stress what material, what part of the product is recyclable, and not state in general, I mean, the product is recyclable, because that would be a deceptive and false statement.
Last big topic, what are the rules on the use of seals and certifications? In the US, one of the big issues is making sure that you don't misrepresent that something has been endorsed or certified by a third party. In other words, don't create your own seal and make it look like it was an independently awarded seal. Here's an example on the right side that was in connection with FTC investigation, product labeled with the green safety shield. The problem was that was not awarded by some organization. It was simply a seal that the company created for its own products. The second thing is that if you're making a seal or certification, you should comply with the FCC's endorsement guides, which provide lots of guidance about what it means to represent that you've been endorsed by a third party. Third, a seal is not a substitute for ensuring that you can substantiate your claims. In other words, even if you get a certification that says that your product is biodegradable, that doesn't take away the advertiser's own legal obligation to ensure that it has proof that its products are biodegradable in accordance with the law that applies. And finally, the FTC warns that many green seals may communicate general environmental benefit claims, in which case the seal itself needs to be more properly modified. Again, if you look again at this example, green safety shield to general environmental benefit claim, it doesn't tell you what the benefit is. That green safety shield, if you were going to use it, you'd want to have a clear and conspicuous qualification right under it that says, it got this award because it's made of 100% compostable materials or something along those lines. Kelly.
Yeah, I would echo all of that. I mean, I think, the main takeaway is you can get a third party claim, but you can't contract out of an advertiser's liability and responsibility for supporting their claims, right? So if you're relying on a third party to give you comfort that your support is sufficient, and maybe they do have some great practices, they've got their own process for identifying support for whatever the claim is that you're going to be making, that's great. But if there's a problem with the claim, the Competition Bureau will be going to the advertiser, and you can't just say, well, they did it and they're responsible. The advertiser is going to continue to be liable for and responsible for supporting their claim. So certainly if you are relying on a third party to help you with your substantiation, get a great rep and warranty about what they're actually doing for you. Have them give you an indemnity and make sure their insurance coverage is going to support you. All of the federal administrative monetary penalties just went up. So you're looking at quite a lot of money, up to 3% of your worldwide gross revenues. So make sure they've got some deep pockets or insurance coverage. And critically, you need to do some due diligence on a third party, right? You can't just get a seal and put your hands up and think that you've done your job. You audit them or get audit rights in your contract. So, there's still quite a lot of work to be done if you're going to be putting that seal on, because, there is a halo effect when you have these kinds of seals, right? So you need to be very careful that your certification is specific and that you're not making a broader claim than what they actually, are supporting on the back end.
Adrian.
Well, in Mexico, I think there are, well, probably in other countries too, but there are mainly two kinds of eco-labels, ones that are granted by the government and ones that are granted by other organizations. So the government ones tend to be more specific about what they are certifying. For example, the Environment and Natural Resources Secretary, they usually give certifications, for example, for things like the wood for this furnace or the wood for these materials come from a sustainable practice in a forest, or maybe come with protection of the forest used by the monarch butterflies. So those are very specific, and in order to be able to obtain those kind of eco-labels, you have to comply with Mexican standards, which are usually easier for the government to enforce because they have been going through all of this process to make sure that the claim is very specific. Like I said, the problem with the other kind of certifications is that since they are granted by private entities, they may be subject to more complications. But that's why it's important, like Kelly said, to make a good due diligence on the background of all of these organizations to make sure that they're a legit organization. They are sometimes backed by international bodies, or they have specific requirements that should be met. But as long as you are using all of those in connection with the requisites that are intended for those certifications, and you can prove that if the authority questions it, prove it by, for example, showing proof that you are a member of such certification group, or that you have all of this documentation and objective evidence that we have talked before, then you should have no problems with that. But and as always, do not use any eco label that you do not have authorization for, because that would not only be an infringement of consumer protection laws, but also probably an IP infringement. So yeah, there could be a whole lot of liability because of that.
Okay, the way it works in Argentina is there is a registry at the Ministry of Environment where companies can file, register, and then are accredited as and able to provide certifications and seals. The most relevant companies are Bureau Veritas and TOB Rhineland, a German company. Of course, you can get also the 14001 certificate for the International Organization for Standardization, ISO. But there is a lot of concern and doubt from many NGO organizations, especially regarding the textile industry. So I rather like to put this short video. So if you can play that. No.
Yeah, I'm sorry. I think it's not. I think it's not working. Sorry.
It's not working? Okay.
Yeah.
Okay, that's it.
All right, thanks. All right, wrapping up, just a couple words from each person, I think, about what's coming down the pipe. I would say from the FTC and from the U.S., we are the FTC is currently in the middle of a review of the green guides. It's a big, lengthy review process. Thousands and thousands of comments have been received about potential changes to the guides. It's not going to be ending anytime soon, but when we do get new guidance from the FTC, I think we should expect to see a lot of really new guidance that's going to impact environmental marketing in a big way. Also, state law is changing. It's continuing to change. And I think that we're going to see more restrictive state laws that are going to be impacting a lot of the practices that people are doing right now. And then finally, lots of litigation out there. We went through a period of many years where these kinds of claims really weren't getting all that challenged that much. And not only are we seeing challenges to these claims, but we're seeing them getting resolved in inconsistent ways, which certainly isn't making anything any more clear.
So in Canada, I mean, I think some of the trends that I'm noticing are a real rise in class actions and nonprofit organization and just, complaints in environmental advertising. Canada's not super litigious. There are some advertising actions, but they're, not as common as other jurisdictions. And we're really seeing quite a number of these. One this year, actually, that just got sorted out on appeal was a class action regarding vehicle emissions claims, which was actually the advertiser prevailed because they were complying with ministry guidelines on how to make these kinds of claims when somebody's buying a new car. So it's kind of comparative claims. And you can see the example there. There's an ongoing class action against Dollarama and a bunch of other retailers about their recyclable, reusable bags. And then there's another, one of these NPO Competition Bureau inquiries into the Oil Sands Producers Alliance claims in a campaign where they were saying, net zero and sustainable and trying to, make claims about the, fossil fuel industry in Western Canada. So I think we're seeing a lot of those. And I think that's an area of increasing risk. And certainly, there's class actions that always come out of Competition Bureau consent agreement. So something to think about, particularly environmental space.
Adrian.
Well, I think that the main development will probably changes in policy efforts. Like I said, for example, we have local laws that are addressing things that federal laws have not done so far, like recycling in Mexico City. And usually Mexico City has some of the most advanced legislation in the country. So once they start doing something, other states repeat it or try to emulate it in some way. So since these kind of activities are now being more heavily, focused in the public eye, I think we'll probably see some changes in that. There is also a program, the National Development Program, which was promoted by the presidency, which included, a whole different points that were supposed to be addressed during this government term. The government term is almost up. We have a change of government next year, so we will probably have to wait and see what the candidates are doing, to try to address these issues. But they will be likely a central point of the campaign that will be coming up. So I think that, like I said, we have to include some laws that make changes in this. But I think that the main problem in Mexico is to actually enforce those laws. So in the private sector, we will be trying to make sure that clients comply with that, to encourage them to comply, and to try to, well, all in all, these kind of problems affect us all more beyond the law, but because of the environmental issue in the world. So I hope that these changes are work for the better, and create some good changes in our country and in the world.
Damaso, any final words?
Okay. Yeah, we don't have a strictly class action rule in Argentina. There is a bill in the Congress, but there has been a leading case, a lobby with the Supreme Court. So we have a kind of collective actions, and I see more of this action by consumer organizations. This is one of the thing I see. Then more strict rules on carbon and emission claims, especially in the oil, mining, and lithium business. And probably from CONARP, a more strict surveillance and control on environmental claims. That will be the main issues.
Excellent. Thank you so much, Damaso and Kelly and Adrian. Thank you guys all for coming. And thank you all for joining us. And please keep an eye out for IAA's next webinar on environmental marketing issues in the fall, where we cover the rest of the world. Thanks, everyone. Have a good day.
Thank you.
Bye-bye.
Thank you.
Thank you.